Hey, this is working. Yeah, all right.
Welcome, everyone, to the September 10th City Council work session. Welcome back from break, counselors, and welcome to our temporary new council meeting accommodations. As I will annoy you with every time, we're 2 years and counting to our next destination. So there you go. You will see on your calendar tonight in front of you committee reports and items of interest, and just want to be sure that we have enough time for a full discussion of the downtown public safety zone. So we're going to move that up to the top, and if we don't have time for the committee reports, we'll do them on another day. And wanted to let you know that because we have to make a room transition, unlike when we had the McNutt room and then went over to council chambers, we're doing both meetings in this room, and so it's my intention that we finish the work session at 7. Everybody vacates the room, and then they'll set up for the regular council meeting, and people can come back in at 7:15. So that's how we're going to try to make it move tonight. And it's a little different, so bear with us. I think we'll just move along smoothly, but we'll appreciate everybody's cooperation and expect the same kinds of great council meetings we're used to having. So there you go.
You thought you'd sing that live.
Okay. Anyway, the item that we're going to be talking about today is the downtown public safety zone, and I'm going to turn it over to City Manager.
Thank you, Mayor, and it's good to be back after a nice long break. Hopefully everybody enjoyed their time off. We have a very busy and I hope very fruitful fall and winter ahead of us. Several important topics that we'll be talking about. The first out the gate is the downtown public safety zone, and so I'll turn it over to the Chief for a presentation, and of course we'll be available for questions. This is a work session. We're not asking for any action at this time. There's a public hearing that would be coming up next week on any ordinance changes, and then eventually we'd be coming back with a final recommendation based on all the input from tonight and at that time as well. So with that, Chief, I'll turn it over to you.
All right. Thank you, Mayor, Council. I'm going to be joined by Lieutenant Sam Kamkar, who I believe you know. Lieutenant Kamkar is in charge of the policing work unit that's downtown, has been working closely with advocates and business people in the courts and the police department to provide the very best service that the police department can. And then I'm sure you know Dan Barkovic. He's the city's prosecutor, works for Glenn Klein, city attorney in central services, and sort of a rearrangement that occurred recently. And then Jeff Terry is also here to help explain what we're offering here. Jeff's the UG Municipal Court Administrator. I think you're pretty familiar with the history of the public safety zone. It has sunset twice now and recently extended through November. We provided you with a little bit of an update this last summer because we knew that there was going to be a short decision-making period here. We committed to providing you since April with summaries of the exclusions that we've requested through the court. You've seen those. Yesterday I sent you a list of every single exclusion request that our officers have completed, even those that have been withdrawn, and what the outcome of those have been. There's been 46 of them from January 1st through August 9th of this year. And we'll continue to do that as long as the ordinance is still in place. The proposal that we're recommending is that the ordinance the sunset date be extended. And since we've seen limited participation in the advocacy program, we're recommending that we provide an attorney to indigent defendants for the hearings that people are allowed to have, the show cause hearings. And then Councilor Ortiz asked an intriguing question that we've kind of struggled with. How do you know when the downtown is becoming a safer place. So we are examining a way to count behavior downtown in an objective fashion, maybe partnering with the University of Oregon, so that we have, so that we're not relying on police activity to know when conditions are improving downtown. And I think that about wraps up my introduction.
Thank you, Chief. Madam Mayor, members of the council, for the sake of time, I'm not going to repeat what's already in the AIS for you, but instead what I wanted to do is to briefly review three specific topics. One is the exclusion process related to EPD. The second one is our new internal guidelines that we have adopted. And last but not least, our need for the exclusion program. With reference to the exclusion process specifically related to EPD, as you know, the exclusion process starts with the arrest by an EPD officer. Now, over the past few months, I've learned through a variety of sources that many are under the impression that EPD officers exclude people. And I wanted to clarify in record that EPD doesn't have the authority to exclude anybody from downtown. Our officers make a recommendation to the municipal court, and they do so by giving the defendant a notice to appear before the judge. The judges review the police report and the testimony of the officer and the defendant, and they render their decision. Now, the judges, rightfully so, have judicial discretion, and at times they've exercised that right to dismiss an exclusion notice, even though the facts of the case were within the parameters of the ordinance itself. Now, our officers continue to notify the defendants of the availability of the advocacy program, and the yellow card we continue to hand out as throughout the process. Now, with reference to the internal guidelines, following the feedback that we received from you, we directed our officers to concentrate their efforts on specifically prolific offenders who are a threat to downtown core area. And as you can see in your AIS, the average person who's excluded has multiple police contacts. And last but not least, I wanted to take a moment to share with you an incident involving an arrest in downtown. On July 19th, our officers arrested a 40-year-old man for a number of charges, including violation of restraining order, resisting arrest, escape, carrying a concealed weapon, and unlawful delivery of a controlled substance. Now, this man has a long criminal history, some of which include coercion, assault, public indecency, harassment. He is also known to our officers to target the at-risk youth and the young adults in the downtown core area. Now, following his arrest, he was released from the Lane County Jail in less than 24 hours. Now, here's a man who fought with the officers. He resisted their arrest and was found to be in possession of a concealed weapon within the downtown core area. And he had 9 individually wrapped baggies of drugs on his person. Yet, he was released from the jail. The only thing that we had left in our toolbox was to ask the court to exclude him from downtown. Fortunately, he was excluded for 90 days, and I'm pleased to report to you that not only he hasn't returned to downtown since then, but he also hasn't been arrested anywhere else in the Lane County. Now, without the exclusion program, as you can imagine, we would not have been able to keep this man from targeting the youth juveniles and the vulnerable individuals that we have in downtown. Now, at this point, what I'm going to do is yield the rest of my time to the city prosecutor, if that's okay, Chief.
Actually, I think Mr. Perry wants to address the council regarding the new proposal to have court-appointed counsel for these hearings. So, if you slide up here.
Good evening. I'm Jeff Perry. I'm the court administrator. So I can just touch on Chief Kern's proposal about a court-appointed attorney. I think that it would be indeed more effective than the advocacy program that we've implemented. I don't think there's anything actually wrong with the advocacy program. We just haven't had a lot of interest in it, and I think it's probably more difficult to access than it would be for an attorney. Our court-appointed attorneys have access to the jail. They see people in custody frequently. They would be there and available to assist a person much more readily than the advocate would be today. And obviously, the level of support would be different. They'd be able to provide legal advice. They might be representing the person already, and so there's some advantages to that. I've spoken to the contractor that we have in place now. They would be interested in performing the service, and so I think we could get somebody on board probably within a month or so. It would be relatively easy to implement that program. Likely, it would be somebody already experienced with the court system and so on. I would propose implementing a separate contract as well, so we could closely monitor the number of referrals that are seen and be able to track the costs as well, which is obviously important. And speaking of cost, my best estimate, it'll be difficult to say, we could see, obviously we thought we'd see more people with the advocate program. We did not. I would guess that we will see more referrals with an attorney for sure. My best guess, though, on cost range would be around $10,000 to $15,000 annually, which is, assuming we have, 50 to 100 exclusions, authorized every year. It would probably be less than that actually see the attorney, though. One of the key things that I think we do need to consider if we do move forward with the attorney is that the ordinance time frame will need to be reviewed, and I think we'll just make a recommendation on that in the ordinance. But it is a pretty tight timeline, and for the attorney to retrieve the discovery and whatnot from the prosecutor's office, we'll need ample time so the person's effectively represented. And other than that, I think it would be relatively easy to implement the program.
Okay.
Any questions?
I didn't mean to cut in.
No. Go ahead.
I just wanted to talk with you a little bit about the kinds of offenses that are on the exclusion list. As we've gone through this, it's important to keep in mind there are really two exclusions that can occur. One is the 90-day exclusion that can be imposed after the person has been arrested or cited, and that's before they've been convicted of the underlying offense. The other kind of exclusion comes after they've been convicted, and that exclusion is for a one-year period. Most of the focus has been on the offenses and what occurs on these 90-day exclusions before somebody's been convicted, but after they've had a right to a hearing. I compiled a list. I looked through the ordinance, and I think there are about between 60 and 65 crimes or offenses on that 90-day list for which you could be excluded for the 90-day period. Of that 60 to 65 offenses, 54 of them are either felonies or cases that are committed only by violating a state statute. In other words, cases that are prosecuted in circuit court by the district attorney's office. Of those 54 crimes or offenses that are on that 90-day list, 50 of them are either felony drug or felony sex crime offenses. So the focus, and a couple of those on that 50 offense of drug or sex crimes are misdemeanors, but they're prosecuted under the state code. We don't have a city ordinance comparable to those offenses. So as you can see, the kinds of crimes and offenses we're talking about on the 90-day exclusion list are serious cases. They're either the felony drug or felony sex crime cases, essentially. And the reason that the manager and the proposal is to continue that 90-day exclusion on into the future is, as we all know, the jail space available for these offenders in the state court system is extremely limited. Essentially, felony drug cases, when they're arrested or cited, really face little, if any, consequence because the jail simply doesn't house them, is unable to because of their current budget situation. So the mechanism that's in place to exclude them from this area that we have designated as an important area is important at the city level for this exclusion process, because the teeth of the felony or misdemeanor offenses under the state court system are extremely strapped right now. So that's the reason why we think it has continuing vitality and is important to the citizens of the city. So that 90-day list is a finite list of offenses. The offenses that could get you a one-year exclusion after a conviction is much, much larger. Many, many additional offenses, including municipal charges that we have. So the list has been pared down to essentially the most important, most visible crimes that citizens, business people, other people who may live downtown noticed over time that was deteriorating really the integrity of the community down there. 50 of the offenses are either felony or misdemeanor drug crimes or sex crimes. So it's a limited list of important offenses, I think.
So I also have Judge Allen here to speak to some of the dismissals that we've seen over the last few months, and we've been tracking those pretty closely. So I'll let you come up.
Great. Judge Allen?
He wasn't expecting that one.
We've had this ordinance for almost 4 years now. So initially, when we had denials of the request for the 90-day exclusion, I don't think we kept any reasons why, and I think it's hard to go back and reconstruct those. But I know the council wanted to hear about some of those things. So we were able to go back almost into February and also the latter part of January. And I think there have been, I think there have been 4 that have been denied. Sometimes they're denied, 4 on the merits denied. Sometimes they're denied because Mr. Barkovic will ascertain that the charge doesn't fit within the exclusion parameters. Other times they're denied because they're filed later than the hearing. So, for instance, if you're cited for any offense in our court and you're cited to appear on the 10th of September and you come to court on the 10th of September and we don't have the papers, that case is dismissed. So there will be those kinds of procedural issues that flow. And I can't really tell you how many there are. I don't think there are a lot. EPD is pretty darn good at getting the paperwork into us. But basically, the ones that I have denied and Judge Moore have denied have been less than an ounce of marijuana in a backpack, that kind of thing, with nothing more, no extensive criminal history, no serious charge, that sort of thing. And I don't think that's what the council had in mind. I don't think that's what the community has in mind, that we're going to exclude everybody that went upon search, consent or otherwise, that they're going to be excluded if they have less than an ounce of marijuana or residue in a pipe or that sort of thing. I think it takes more than that. So I have reviewed the guidelines that EPD has put out, and I think, in my view, I wasn't a part of putting out those guidelines, but that's the guideline I'd use. I think those guidelines are pretty darn accurate in terms of the way that we should use our discretion. And I've had that discussion with the other judges, and there is no dissent from that we feel like that's pretty well put, pretty articulate. So if you continue it and if you have us still exercise the discretion, that's the way we would do it unless you tell us in a different way.
Thank you.
Happy to answer any questions that anybody might have.
Mayor, that's the overview we wanted to provide.
Thank you all very much. And I guess I had a couple questions. I'll start out with, and I'm going to call on Mike. So, are the folks who are being given notice of possible exclusion, are they verbally notified of the hearing process?
No, they have to be served a written notice to show cause to see whether or not they should be excluded. Setting up an appearance date, I think within 3 to 5 days, for them to come into court and request a hearing. And if they do, and they choose to have a hearing, then the court, I'm assuming, gives them some written notice of that hearing date, which then must be within 14 days of that first appearance date. It's written notification.
So is the response to showing up for hearings for this group different than you find in your other part of the system?
Well, it's a big system. I mean,
Well,
people you have.
I guess what I'm trying to determine is, are we giving them the proper information or enough information to assure as much showing up for hearing as possible, or do we just have a general not showing up for hearing kind of practices that are going on that are no different here than they are in other places? That's what I'm trying to understand.
I think you have a huge proportion that don't show up. And I think they're given clear notice, both verbally and also by the paperwork that we review to make sure that they got that notice. But we have very few hearings because very few people on a percentage basis or a number basis request a hearing, and even those who may request a hearing don't necessarily appear for that hearing. Now, if you have court-appointed attorneys who are appointed at the jail, keeping in mind that we see these people at the jail in the jail courtroom, and in theory we would see them downtown. So if you were not taken to the jail or you were released before the court appeared, then you would appear at downtown or at 11th and Lincoln, the new courtroom. And if not, then you appear in the jail. So if you have a court-appointed attorney who is automatically appointed in the jail, you will have more hearings whether or not those people appear. And the reason is that in my opinion, the attorney has to have the hearing. He doesn't have any authority from the client to waive the hearing, and he also has an underlying charge that's waiting in the wings, and any attorney worth their mettle is going to have basically a preliminary hearing and hear what that case is about. So I think anytime you have a court-appointed attorney, I would expect, although nobody's told me that we're going to have a hearing. And the length of that hearing is going to vary.
All right.
Having said that, if they don't appear, the people who are released before they have a court-appointed attorney, and the people who are maybe cited and are not taken into custody, and who are supposed to appear downtown, I think you'll still have the same FTA rate, which is very, very high.
Thank you. Mike.
Thank you. Out of general curiosity, do you happen to know, Your Honor, the failure to appear rate for Lane County for the circuit court system?
For the circuit court, I don't, but it's huge.
My understanding is like 42%.
I was going to say 40, but it was a shot in the dark. I would think a good solid 40%.
This ordinance is one that I've supported the time that I've been on council. It's one that I've been hearing a great deal about from other downtown business folks and their support for us continuing this. I would like to see us continue it by extending the sunset for 2 years, for another 2 years is a reasonable way to move forward. And frankly, with due process as a consideration, and I'd be open to the idea of the court-appointed attorney as a part of this. I think that's a reasonable discussion to have, and I'd be happy to have that and be very happy to consider it. One of the kinds of conversations, though, that we always get into at council about this ordinance seems to be around what it's a remedy for. And while we have all of you gentlemen here, I'd love to hear from you on this, because it has always been my proposition that this is a remedy for the lack of space at the jail. And we often get into a conversation at council about how it's a remedy for the lack of officers in the downtown area. And now that we have an increase in officers, maybe we don't need this. Again, as I've always thought, this was a remedy more for the lack of space at the Lane County Jail, and also as a safety measure to keep people apart who may do one another harm, like a restraining order would be. But I would love to have each of you comment on the effect, or what this is a most effective remedy for, from your perspective.
You know, the whole broken window theory is based on the reality that behavior, when repeated, becomes a norm. And so if we don't change the norm in the downtown area, then where crime is most concentrated in Eugene, if we don't change that norm, then it will continue to be the same or grow worse. And absent a jail, a place to incarcerate people who are committing these types of crimes, this is a way to disrupt that sort of behavior. And it does feel with the added officers as though we're gaining some momentum, and this feels like a good time to keep that momentum moving forward. And I'm concerned that without this tool, it could make a difference. How much? I don't know.
Well, Councilor Clark, we can practically put a police officer at every corner in downtown. Without the adequate jail space, it's not going to solve our problem.
And so this is a remedy for the jail space, really more than the number of officers we have.
That's correct.
Okay? From the prosecutor's perspective.
Well, I mean, just to echo those comments, I mean, 4 years ago, we had very little law enforcement officer presence downtown. We had probably more jail beds 4 years ago with the county for those types of felony offenses or state court offenses. Now we have more officers, but far, far fewer jail beds. So we're really in about the same spot practically as we were 4 years ago, even though the city has upped its efforts significantly to have a visible presence of its police officers. On the back end of it, the county, through budget problems, has scaled back their law enforcement efforts. So we're really kind of in the same spot as we were 4 years ago. A different reason, but similar spot.
Well, I think the threat is that if you're excluded and you violate it, you're going to go to jail, and you're going to go to the Springfield jail. And that is not insignificant to people. Time and time again, I'll say, you have X number of days in jail, and that'll be at the Springfield jail, and they'll say, oh, no. Can I go to Lane County? Can I go to, no, you can't. You've got to go to Springfield. So it does come with a reputation. It comes with a reputation of austerity, for lack of a better phrase. And I think that may be the threat, the idea that if you violate the exclusion, here's what's going to happen.
And that's because of our agreements with Springfield to be able to use their facilities as opposed to them not being held at the county jail. So they may actually be held accountable for something with the exclusion in place.
If you were just buying beds in Lane County, you'd have, and in the current budget situation, you really have to take a look at the expense of this. I mean, because our Springfield beds are far, far less expensive.
Right. Thank you, sir.
Yeah, I've got George Brown and George Polling and Betty Taylor. George Brown.
Thanks, Mayor. I've got some questions about some of these proposed changes. The first possible change, is eliminate the 90-day exclusion. This would leave the 1-year exclusion. I just would like to kind of state the way I have interpreted this information and then see if I'm off base or if it's reasonably accurate. The way I understand it, if the 90-day exclusion no longer applied, someone would ultimately be excluded only after they've had a hearing, a trial, and been found guilty of the underlying offense for which they were initially cited. Is that correct?
Yes.
All right. So that means that someone would be, given a citation following these guidelines, which is nice for us to see these guidelines, by the way. I do think that, I personally think they're pretty reasonable. So somebody gets what, they get a citation for exclusion. They're not excluded yet, though, until after there's been a hearing and they've been found guilty of the underlying offense. Then they, at that moment, then they can no longer be in this zone. Is that
Actually,
correct, or are they excluded before that?
for the 1-year exclusion, they don't get a citation. What happens is the officers document their intent for the exclusion or the request for the exclusion on a police report, and then from that point on, it goes to either the circuit court or the city prosecutor's office, and then once the person is convicted, then the process goes into effect.
That's when the exclusion starts, after the conviction,
That's correct.
and only after the conviction. So they could still be downtown up until that moment. Okay. Well, you know, I like that, and I will only support any kind of I've kind of changed my mind about this. I'm not totally there yet, but I'm almost willing to support the continuation simply because that removed my major objection was, you know, it was kind of like this is one of the things that differentiates America from almost every other country in the world. It's like you're innocent until you're proven guilty. You know, a lot of countries it's not that way. You get tossed in prison or jail or whatever, and it's up to you to prove your innocence. It's kind of hard to do when you're incarcerated. So I like this a lot better. And I am not opposed to the idea of exclusion, by the way. I mean, I've had, been downtown 42 years now. And, there's some obnoxious behavior, and we generally deal with it on a day-to-day basis. And I think we do a pretty good job, but, we have restraining orders on individuals who've exhibited violence and bad behavior to a spouse or a relative or somebody else. That's a valid legal tool to use. Just keep them away. Stay away. You can't go there. And I think it's okay in certain cases for public space, too. I think the mistakes were made in the first couple of years of the program. I like what I see better, and I do appreciate the more detailed reports that we're getting, the summaries.
Want another round, George?
I'll need another round, yeah.
George Poling?
Okay, I have a couple of questions about the court-appointed attorney, which I think is a good idea. It's just that in the AIS on number 4, council options, it says provide court-appointed attorneys for all people receiving a downtown public safety zone notice to appear. Is that all people that qualify for a court-appointed or just all people?
It's not my proposal, but I understand it's all people who are charged with that offense. And I don't think it makes a lot of difference because I think that you're going to find that they all would qualify. I am very liberal in terms of giving people court-appointed attorneys, and I twist their arm every day of the week to have them see the potential consequences when they try to waive an attorney, and many times, most of the time, they'll change their mind. So it is everybody, but I don't think it probably really matters.
And then the other question I had about the court-appointed attorney is if they already have a court-appointed attorney for the underlying charge or an additional charge.
Wouldn't even have it yet. This happens so fast that the arraignment on the other charge generally doesn't happen yet. It can,
Okay.
but sometimes it doesn't.
Okay. So this is kind of getting into the financial end or the billing end of it. Would then the attorney, the court-appointed attorney that's contracted, bill for just the one service for defending this person for the underlying charge and the exclusion, or is it going to be separated out so we can keep better accountability, or how are we going to address that?
Well, if I could comment, as I say, most of the offenses where somebody is, where the city is seeking a 90-day exclusion are going to be circuit court cases. And they may very well get a court-appointed attorney on their circuit court underlying charge. But what this proposal talks about is that they would also get a court-appointed attorney for the exclusion process at the municipal court level. So it's conceivable they'd have a, and see, we don't have any agreement with any circuit court, court-appointed attorneys to do this work. So what they do over in circuit court is separate from this exclusion process.
Okay.
Pre-conviction.
Okay, very good. All right, thank you. Then, I too have been very supportive of this exclusion zone since its concept. I think that the 2-year extension is a good idea. This is just one of many tools that we have currently to help improve the downtown. The most important, I think, is the two most important is the increase of the number of officers that we have on duty, as well as all the redevelopment that's going on. And I think it's going to take us at least 2 years of current staffing by the police department and the development going on to see if this exclusion zone is really needed at the end of the 2 years. Is all this infusion of activity in the downtown, is it going to make this exclusion zone unnecessary, or can we scale it back, or what? So I think a 2-year extension is a good idea. And, like I said, it is just one of many tools that we have to help improve the climate of the downtown area.
Did you have something you wanted to add to this?
Oh, just as far as the structure of the court-appointed attorney contract, I would propose issuing a separate contract. It would likely be with our existing contractor or a subcontractor within that firm, and then have them bill it separately. So we could just treat it as a different agreement altogether, and it'd probably require a little quicker turnaround time and a different level of service than we have now. So.
Thank you.
Eddie?
Thank you. First question, what percentage of the people excluded are excluded for marijuana, do you know?
No, I don't have that off the top of my head, but we can get that information if you like.
And when you say sex crimes, does that mean rape?
Yeah, the 90-day exclusion list initially didn't have any sex crimes, but in one of the later iterations, rape in the third, second, and first degree were added as excludable.
So are there that many rapes downtown?
I don't believe there are, but there was one when these offenses weren't on the 90-day list, and it came as a kind of a disappointing shock to a lot of people that how come we can't have an exclusion for somebody who has committed a sexual crime like that. So those sex offenses were added, I'm thinking, maybe 2 years ago.
I remember, but I wonder why you call them sex offenses instead of just saying rape.
Well, because there's charges of sex abuse in the first, second, and third degree, contributing to the sexual delinquency of a minor, prostitution offenses, compelling prostitution, and a few other sex crimes, sodomy, first, second, third degree. So we added probably 10 or 12 sex crimes in addition to the rape charges on the list, to the list.
How many of these people would you say are dangerous to other people? Anybody?
Nearly all.
Would having marijuana be dangerous to other people?
Well, the marijuana may be the underlying charge, but like in the case that I mentioned earlier with the 40-year-old man, this is an individual who is using marijuana to finance his business, and in the meantime, he's preying on young people. And
Preying on them how? By selling the marijuana?
by selling the marijuana, as well as, like in this particular case, we are currently investigating a sex crime involving this individual. So,
Sex crime meaning rape?
well, not necessarily rape, but without going into too much detail, taking advantage of younger folks, like a 15-year-old girl, inappropriate touching, things like that.
If these people are dangerous, and if you could send them to the Springfield jail for violating the exclusion zone, the exclusion order, why can't you send them to the Springfield jail in the beginning? For the judge, I guess.
Well, you can't do it in the beginning, you got to do it at the end.
I mean, after they're convicted.
Of course. You
Then,
can put them on probation, and you can put one of the...
then you wouldn't need
probation.
the exclusion tool.
Sorry?
Then you would not need the exclusion tool if you're going to wait till they're convicted.
I don't need the exclusion tool. I'm not advocating one way or
I'm just saying, I don't mean you personally, I mean people, we, then.
The Springfield jail can only house misdemeanor offenders. That's one limitation that it has. It can't house anybody who's charged or been convicted of a felony. It has to be a misdemeanor.
And, Counselor, if I may, the municipal court can only afford 25 jail beds, which is not enough in order to retain the people that are committing these types of offenses that are not being held by the Lane County Jail.
How many people are currently excluded?
I don't know how many are under exclusion currently, but 46 in this calendar year have been subject.
But they're not still.
Not all of them, no.
And there might be a possibility of putting them in jail for a while to make them think about it, right? If they're doing something really bad. If they're really dangerous, I think that we should find a way to not put them out in the rest of the community, but put them someplace where they can't get to anybody.
Yeah, I agree. As you know, I think that the jail has reduced its number of jail beds by 180 in the last 12 months, last 14 months.
I know that.
So the jail isn't holding people that are committing even more serious offenses than are subject to this exclusion ordinance.
Are there any people in jail for drug offenses?
Yes.
Are they dangerous people?
I don't know what the population of the jail is.
Okay. Has anyone followed the person who's been excluded and for some time to see where that person goes, where he or she is? Does anyone check up on them? Similar to a parole officer or something?
No, we do not have a parole officer, or we don't follow these individuals once they're excluded. What we do know is that our officers do occasionally see these people come to the downtown area, like in the case that I mentioned earlier with the 40-year-old man, but he doesn't set foot in the DPSC zone because he knows that he would get arrested. And as soon as he sees our officer, he does an about-face and disappears. But we also know that this particular individual and many like him have not been arrested for other crimes in other places in Lane County. They may have gone to a different state, but at least Lane County.
But we don't know that they aren't committing crimes that nobody knows about. I worry about people who, if they're a threat downtown, I think they might be more of a threat in a park or near a school, out by the river where no one's watching them. And
I can
yes.
respond to that if you like.
Okay.
What we know in law enforcement today is that where we can disrupt concentrations of crime like that which we have downtown, that it does dissipate, and those people may gather in smaller numbers elsewhere, but crime will go down when we can dissipate it. And this is an instrument that allows us to do that. So we found it interesting that last year the last time we provided a comprehensive report on the effect of the downtown public safety zone, and when people weren't being arrested downtown, many of them weren't being arrested anywhere in Lane County. Now, you're right, they could be committing those crimes in their homes or in other places, but the reality of crime, as we understand in the United States, is that as we disrupt it, it can be reduced over time.
Don't we also know that if you have a lot of people in one place, everyone's safer?
Depending on who those people are, yes.
Well, I assume that there'd be some people there besides criminals downtown. And as we get more people, and we also know that if there are police or even a police car, people are more likely to behave.
That's absolutely true.
I mean, we all are. If I see a police car, I think, did I do something wrong?
No, you wouldn't have done anything wrong.
Never, but I think it has an effect. Just looking at the uniform or looking at a car has an effect on people's behavior.
Yes.
And I would like to see us try a year. How about a year without an exclusion zone and sunset that in a year and discuss it again? Thank you.
So before I call on Chris, I'd just like you to, for the people in the room and the people at home, I don't actually think people understand all the people who cannot be housed in the Springfield jail, and I wish that you would explain who can't be housed there.
Sure. Probably none of us is...
Well, I'm just thinking that, for instance, women.
Yeah, the Springfield jail doesn't house women, only men, and only men who've committed crimes that are not tried in state court. So only municipal, Springfield, and Eugene, people held on municipal, Eugene, and Springfield charges, and who are healthy.
And who are healthy. That's the other big one. So you can't be a person who has multiple needs or whatever because you can't be housed there. So it's a very limited, important, but limited population that they can deal with there.
And if I could just clarify one thing, you might have had other comments you were going to make.
No, that's fine.
This is, I'll tell you that this can be a confusing ordinance to understand because of the list of offenses that involve the 90-day exclusion, the list of offenses that involve the 1-year exclusion. And in the list, under the council options in the AIS, one of those is to eliminate the 90-day exclusion. The city manager's recommendation is that we retain the 90-day exclusion and the 1-year exclusion. What would change is that for that hearing for the 90-day exclusion, there would be, the defendant could have an attorney to represent them, which is a significant difference, and I'm confident that we can carve out this place so that that practice isn't expected to migrate into traffic infractions or other civil hearings.
Thank you for clarifying that. Chris.
Thank you. My goal, as I know, many other people's goal is to ultimately get rid of the exclusion zone. I mean, the ideal world is where you don't have an exclusion zone. But how you get there and what you do in order to get there, I think, is really the key element. And I think just getting rid of it and going back to what we were, to me, is not reasonable, because I have also, as Lieutenant Kamkar has, have many examples of stories of how things used to be before we had the exclusion zone. And with as many problems as the exclusion zone may have, I think it was far worse when there was nothing in place to deal with that behavior. And we even had more jail beds. I've heard, and this is kind of a little bit of what Mike was talking about, that at the core of the strategy to get rid of the exclusion zone would be if we had more jail beds. And I mean the regular Lane County type of jail beds. And I don't know if I'm being overly simplistic, or whether realistically, if we had enough jail beds, and I don't know what enough is, but if we had more jail beds, we could be working toward that solution of getting rid of the exclusion zone, because that then would provide us with what we need. Am I being overly simplistic?
No. No, and the people subjected to the 90-day exclusion, they're people who would be held in the Lane County Jail, not in the municipal court jail beds, because we're arresting them for state charges. So without the exclusion, we're not inconveniencing them very much. We put them in jail and they're released shortly thereafter.
So when we can come up with a viable alternative, I'll be the first in line to get rid of it, but I need to keep it in place until we can come up with that alternative. With that said, I want to work towards making this as tight and as reasonable in its execution as it possibly can be. And I appreciate your moving in the direction. I think having representation is a tremendous idea, because navigating the legal system can be a real problem. And if you're having to know what to ask for, a lot of people don't even know what to ask for. And you can hand them cards, but they may not even know what that is. But knowing they'll have representation right there, I think is an important element to the process. For me, also, and the last thing I want to talk about is, when we talk about the conditions, I just want to make sure that folks recognize that the first condition, repeated criminal behavior, that's a kind of an obvious one. You see them doing it over and over again. And the third one, persons who are engaging right now in a serious crime, that's another one. You're seeing them doing it. But the second condition, persons with an extensive or serious criminal history, as kind of a basis, it's kind of like pretext, and that's the part that I've talked about before. You want to make sure that that's the area where you're always on good, solid ground. For I know this person has an extensive history, and you may know this person has an extensive history, but to the casual observer, they don't know why you're hassling them. And so you need to be able to make sure that you're in very good, solid ground with that. And that's why I think it's important for the officers to understand exactly how that particular one should be applied. Because I think it's an important one. I think it's one we need to work with.
Pat?
Thank you, Mayor. You know, I'm highly intrigued by what Judge Allen said. If you violate the exclusion, you will go to the Springfield jail. And I'm intrigued by what the defendants typically respond with is, oh, don't send me there. That tells me a little bit about the Springfield jail. You know, based upon that, you know, the Springfield jail is less expensive, it's less desirable. Maybe it's a greater deterrent. Perhaps something that we need to look at in this community is more beds on the model of the Springfield jail, understanding that it's a restricted clientele that it serves in Springfield. But you know, if it's not desirable, it's less expensive. Gosh, it seems like a bit of a intriguing prospect to me. Not something we would discuss at this table, but something perhaps for down the road. I have a question regarding the court-appointed attorney, which I'm in favor of, as others have stated that they are at the table. Just regarding what the attorney is responsible for. Am I correct in assuming that the attorney is responsible or is appointed simply for the hearing and not to see the case to its fruition if a charge is filed against the defendant? So it's just a, pardon me.
Yes, that's true. The contemplation is there would be a court-appointed attorney made available for the person for the exclusion hearing. Mm-hmm. And if the charge is one that originates in municipal court, they may very well be eligible for a court-appointed attorney on the underlying charge. And more likely, if it's a circuit court or a state court offense they've committed, they would be eligible for court-appointed counsel on that offense, but through the circuit court.
Using a different process to appoint for that particular...
Yeah, the circuit court would make those appointments, not municipal court.
So the court-appointed attorney is as much as anything to help the accused person kind of navigate what may be unfamiliar territory, just so they have the answers, they know what they can expect, know the questions that they can ask.
Exactly.
And therefore, you stated that we're expecting, was it 50 to 100 exclusions this year, and that it was, and we're looking at $10,000 to $15,000 total cost?
Yeah, I just looked at historical data and you know, just kind of ran the numbers on that. I think Chief Kearns mentioned we had 47 exclusions this year, so the numbers are actually a little lower than they have been in prior years. And I calculated, you know, maybe half of that number actually seeing the attorney, and then you know, then correlated it with the costs of our current attorney contract, came up between $10,000 and $15,000 annually.
Seems like good reasoning on on your behalf, but it also seems like a pretty good value for the dollar, that people who potentially are not guilty or are not prosecutable have a way to understand the system and perhaps avoid further prosecution. So it seems like absolutely an excellent program. $10,000 to $15,000 for 50 to 100 cases. Where do you get in line for those attorneys? Thank you.
Andrea?
Well, I've been having a lot of heartburn around the subject, and I've said a lot about it already, so I'm not going to repeat what I think or how I feel about it. But I just have some questions, and I wanted to kind of respond to some of the things that I've heard around here at the table. So we're talking pre-exclusion days. We didn't have as many police officers on the street at that point in time, so I don't know that continuing this is going to be helpful or not. I think that officers do deter crime, and I do understand the issue around the beds, but I also know that there's a lot of officers assigned to downtown, and that kind of should be a deterrent in itself. I also wanted to speak to the community. If you're looking for the information around this report, it's on our city website. And can somebody talk to the reasons why the names are redacted? It's all just case scenarios.
Because these are very preliminary in the case. It's only these, you receive these summaries shortly after the arrest is made, and I'm just uncomfortable releasing that at that time. It is a public record, so we could provide many more details, but I'm just uncomfortable with that at that time because many of the defendants aren't even represented yet.
So as we go down the road with this, as I assume we will that information be available for the public? I mean, all of the records, all of these court issues are part of public record. People just have to do a search for it. So for people who are looking to kind of gauge whether, there's any issues around this, is there going to be a way for them to be able to, outside of doing a record search individually, are you going to be compiling those together in a report like this, but with the information on it?
To include the names? We can consider that. Just sitting here now, I haven't thought through what is at stake by doing that.
Yeah.
Privacy of the people that have been arrested.
Well, I understand that, but I just wanted to share with you some of the community concerns that I had. I think that court-appointed attorney is a good idea. I think it's a good bang for the buck, and so I would be supportive of that. And thank you guys for coming.
Okay, George Brown?
Thanks, Mayor. I've got a couple more questions. The court-appointed attorney, Judge Allen earlier said that, typically they or I believe it was Judge Allen, it might have been Jeff or somebody, that they contact people only thereafter in jail. I mean, how would a defendant, they aren't in jail. They've received, the citation or and been notified if they have to be in court on a certain date. How do they find out about the court? How would they find out about the attorney if they're not in jail?
I can speak to that. So, obviously, if they're in custody, the attorney, the judge would see them potentially if they weren't released early, and then they could refer them to the attorney, and then they would just set the hearing. If they aren't, number one, the discussions we've had with police would be to treat it similarly to what we've done with the advocate program, where there's a card, and I think Sam mentioned the yellow card, and we could have the attorney information on that. We also had some discussion about putting it on the notice as well, and so here's who you can contact. And also adding to that, I think Judge Allen spoke to it as well, because of the timing and so on. We're looking at appointing an attorney in all situations. Part of the reason for that, as well, is right now we have an affidavit, a financial affidavit we make people fill out and go through, and that's reviewed before we appoint the attorney, just to verify they're indigent and eligible. We wouldn't do it, and that would actually help expedite the process, but it also allow us to just refer people to the attorney right away rather than go through a court process. So there's some advantages to that as well.
Okay, that makes sense. I've got another question here, kind of regarding the timeline as it exists right now, of the difference between, say, a 90-day exclusion and a year exclusion. Let's say somebody is cited, they're arrested, and then the exclusion order starts for the 90-day exclusion. They have to show up at court. How many days in general does that play out until the judge issues the exclusion order?
You mean for a conviction?
No. Well, pre-conviction. We're talking about exclusions before anybody's been convicted of anything.
Well, I would think that from the time they're handed the show cause notice to appear in court on the exclusion request, that date has to be within 3 to 5 days of when they get the show cause notice.
Okay.
And so if it's on day 4 that they're supposed to appear in court, and if they appear in court and request a hearing, then the court has to set that hearing within 14 days of that initial appearance. So, ultimately you're talking about maybe 18 or 19 days from the date that they're given the initial notice to show cause by the police officer.
Okay.
Is a rough time frame there.
Okay, thank you. And then is it roughly the same or similar time period for the 1-year exclusion?
No. When they're convicted, they can be excluded immediately upon conviction.
Right. Okay.
So there isn't that same time process that goes on. Now, if they're convicted of something in circuit court, that carries a one-year exclusion. Municipal court only knows about that when we get information either from the district attorney or the police officer whose case it was and becomes aware of a circuit court conviction. We then order information from circuit court, provide it to municipal court, they review it, and they can issue a one-year exclusion after that date, effective the date they were actually convicted in circuit court.
Sure, okay. I guess I should have framed that a little bit differently. I meant, say, between the citation or, the initial arrest or citation and the court appearance. But just generally how long that takes.
Well, that's really variable because from the time you've been arrested or cited to when the person gets convicted depends on so many variables, such as the case being postponed or failures to appear. So it's hard to really generalize about that, but it would be at the earliest probably 3 months or 2 months from the date they are arrested on a one-year case to when the one-year conviction would go into effect.
I see.
But if the case languishes for a period of time for whatever reason, it could be 2 years before they're actually convicted of the underlying offense. So it just depends on a lot of factors that are hard to really categorize.
Okay. Well, my understanding is the municipal court judge, anyway, can issue as part of the sentencing of basically any case can include an exclusion.
If it's
at the discretion of the court.
Yeah.
If it's on that list.
If it's on that list, the court can issue an exclusion for 1 year. It still is discretionary with the judge, even after conviction, to decide whether to grant a one-year exclusion, so long as the offense is on that list.
Given that, I'm still having a hard time why we need this whole structure, given the fact that the court already has that discretion. So I'm still struggling with the idea of why do we need this whole zone, because they can do that anyway for cases like this, as well as,
Well, if the ordinance were not in effect to allow for a one-year exclusion after conviction, the judge could not do that. The judge might be able to make a condition of probation that they not go in the downtown safety zone for 1 year, which is a similar sanction. Right. But then that is a somewhat cumbersome process to initiate a probation violation. It requires notice to the defendant of a probation violation. And so it's not as nearly as effective.
I see.
It's the same idea, but it's a different process.
Okay. Thanks. I just have I think that's most of my questions. I do have a comment, though, about when we received I think I have enough time to get this in. When we received the exclusion notices, I noticed some of them said, quote, the subject's exclusion order was dismissed per a municipal court judge's judicial discretion, and 2 or 3 of them were that way. And if we could just have a little more detail about that, just for information. I mean, in the future. I don't mean right now. Kind of like that's what the auditor does with their yearly report. Every single complaint there's all the information that we need, and it would just be good for our information, I think.
Chris?
Do you remember, off the top of your head, how many officers we had in downtown in 2008?
2, I think.
Two. I'm thinking 2 or 3.
We haven't had more than 2 for many years.
Okay. So the notion that there was not a lot of police presence downtown in 2008 is certainly a legitimate one, and having 9 is certainly a lot more than we had back then. So I appreciate that just the sheer numbers does make a difference. So I'm going to pose a hypothetical, and this might be something to try to aspire to. If we were to, however we were able to do it, to get more jail beds, would it be possible to be able to, through the use of jail beds and the application of the convictions that we could do and the actual power behind that, to be able to get rid of the exclusion zone, knowing people would go to jail, and also reduce the number of officers downtown. In other words, redeploy those officers to the rest of the community, because I also am aware that there's other parts of the community that would love to have that police presence as well. I'm not looking to reduce the number of officers, I'm just looking to redeploy them in a way where we could actually serve other parts of town. Am I wishful thinking to think that we could, if we could get more jail beds, to be able to maybe someday get rid of the exclusion zone, reduce the number of officers without compromising the safety and integrity of downtown? I know that's a hypothetical, but...
But those are the most fun to try to respond. The vision is to have a police department that is a precision instrument that focuses its efforts where it's needed most. And where we've struggled is how to count the occurrence of quality of life crimes or behavior crimes, because they don't only happen downtown, they happen in the parks in the spring and summer. And so right now all we have is complaints that either come into the 911 center or through other sources. If we can find an effective way to count quality of life crimes, those officers today will go where they're needed. They won't stay downtown because of a belief that a presence of 9 officers is needed there. They'll go where we know they're needed most.
Oh, okay. That's good to know. Thank you.
So if I understand this right, Chief, what you're proposing right now is, in keeping the 90-day exclusion in place, is that, yes, you want to keep the 90-day exclusion as a shorter exclusion than the year exclusion, but that would not take place without representation for the individual. And that is your effort to respond to the civil rights issues that you've heard. So the question for us as I'm listening to people, does that make any difference to anybody? I heard people who were already for it, as it was before, saying they're still for it, and they like this as a add to it, but I'm not necessarily sensing there's any change in the positions around the table because of that particular piece of trying to put in that civil liberty piece that they heard people were concerned about. So I'm just posing and asking that question, because I think I heard both Counselor Clark and Poling and Pat and Chris, pretty much in keeping the exclusion zone going as we know it, and they like the new change. And I heard both Taylor, I think, and George here say, well, I'm still not convinced, and not sure about you, but anyway, I'm just posing to you that I'm not seeing that the effort to answer your concerns has convinced you or changed your mind. And I guess that's true. Yeah.
My response is I appreciate it because it gives me a good response to people, my friends, who say, well, why would you violate people's civil rights? So, well, why would you try them, or why would you convict them or prosecute them?
I understand that, and I heard everybody say they thought that was an improvement.
No, it's just makes it easier for me.
Mayor, I want to clarify a little bit there. I actually said that I like the ordinance proposed with a 2-year extension and as is. What I said was that I'm willing to consider that as a way to move us forward as a group. What I'm not interested in is doing that just because I think it's a great idea. I'm interested in doing it to answer the concerns of those that have concerns with this ordinance, the other counselors who may need something else as a part of this to garner greater protections for people. I'm willing to meet them halfway in this way if they're willing to talk about their concerns more fully. Now, one of the things I just want to point out is that what Acting Captain Cam Carr said here just a few minutes ago was that we could have an officer on every street corner, and without the jail beds, we would still need this. And I don't know how anyone who deals with this downtown every day could make the point any more clear. Thank you.
Any other comments? If not, I think you've got, but, yes.
One other thing that might help for you to hear is that is what that hearing is like, that 90-day exclusion hearing. You know, in every criminal case, the main event is the credibility of the evidence and the credibility of the testimony of the government's case. And that's what should happen in that 90-day exclusion hearing. So I don't know if you two could comment on what that's been like already, even without representation, and what it might be like with an attorney.
Well, I've conducted a number of these hearings myself for representing the city, and with defendants who are representing themselves, and in one instance where they were represented by an attorney who essentially volunteered their time. So the defendants who represent themselves in many of the instances are aware of their right to cross-examine witnesses. It's no different than many of the other trials that occur in municipal court. So the judge gets to hear all the facts, and sometimes they rule that an exclusion isn't appropriate for some reason, and other times they do. So every defendant has the right to testify or not testify, whether they're represented or not, and some do, some don't. The case we had where there was an attorney, he chose to call his client, and an exclusion was granted after that process. So it's really not too much different than the daily business that occurs in municipal court.
Anything else anybody has? All right, thank you very, very much.
You're welcome.
We have about 20 minutes left before we want to end our work session. You have an option to do the city reports and items of interest, or to get the consent calendar off the list for the later meeting tonight. What's your preference? Betty? You want to do
items if anyone has any. I do.
Okay, all right, we'll do that then. Anybody have any items of interest? Yes. Betty, you want to go first?
I don't care if I go first or not, but thank you. Yes, I have some constituent concerns. Well, this is my concern too, the increase in the parking fees. I know that the reason given was that they haven't gone up for a long time. Neither have people's incomes gone up for a very long time. And I think it's not a good thing for people who are poor. It's not a good thing for our downtown that we're trying to get people to come to and feel welcome. And you do not feel welcome if you have to pay a lot of money to come downtown. And as one person wrote, you'll just go some other place. I know that's what I did. If I was going out to lunch on my way back from Corvallis when I was teaching there, I would think, I'll stop downtown for lunch, and I'd think, after we started having parking meters, I was here when we didn't have any. After we did, I thought, no, then I'll have to pay extra. I have to pay for lunch, I have to pay a tip, I have to pay for parking, and if by chance I meet somebody and start talking and don't get back, then I have to pay a fine. And it was a deterrent, so I'd say, no, I won't stop downtown. And I think lots of people will decide. I would like to see us try the experiment of having all of downtown free parking the way it used to be, while we're trying to revitalize downtown and see what the effect is. And I think that would be a good investment of money. We'd probably save money too if we tear those meters out. We wouldn't have to maintain them. And we wouldn't have to have somebody checking the meters all the time. And then the other thing I wanted to bring up is a person who has asthma and is very concerned about the burning in the wetlands. And I understand there are other things we could do. That's the easier thing, just as it was easier for the farmers, the grass seed farmers, to burn their fields. But maybe we should consider manual removal of things, of invasive things. This person said not only is it very she has asthma, and it's very bad for people with asthma to be near the smoke. It's very bad for very young people and sometimes for very old people, for people who are frail in other ways, and also for animals. We have a lot of animal life in the wetlands. And the person said, what about the birds? They're very delicate. And the dragonflies. And since we got rid of field burning, maybe we should try to get rid of this burning too. So I'd like to know if there's a way that we could do that and if it's being considered.
What I'll do, and it seems like a couple years ago, we sent out some information on burning of wetlands and why that was important versus not burning.
I know.
What we can do is we can go back and take a look at that. I just don't remember the reasons.
Why the state
for-
made an exception.
Yeah, and I'm trying to, I just don't remember, so we'll come back and,
I remember that happened and vaguely why, but still, is that more important than people's health and comfort? That's,
right, okay.
I think we should reconsider, even though it may be easier, it may be better in some ways, maybe the negative aspects outweigh that.
Okay. Well, I'll have to go back and take a look and circle back around with the
I
council.
think I know what it said, but in spite of that, thank you. That's all I have.
All right, George?
Well, just to share with everybody, this weekend I went up to the Seattle area with a large family gathering. My mom turns 95, so we had a big party. But on Saturday, I opened up the Seattle Times, and on the front page is a prototype of Archimoto's vehicle. They're having some kind of a symposium of some kind in downtown Seattle of the new fuel efficiency and electric vehicles and stuff. And of all the vehicles and all the car makers that were there, I found it rather interesting that Archimoto made the front page of the Seattle Times. So I was kind of glad to see that. Was able to share that with my relatives from other states, that it was a hometown
Very cool.
product.
Any other items of interest? Yes, Bev?
Just a couple of things very quickly. We recently had a retreat. The Human Rights Commission had a retreat, and it went very well. We got a lot of issues out on the table as far as interpersonal relationships on the Human Rights Commission. And Michelle's been pretty closely involved with that, and no longer as much. But I really have a really strong feeling for the future of the Human Rights Commission. I believe that we're moving in the right direction there. The other thing is, over the weekend, both Councillor Pryor and I had an opportunity to visit Willamette High School, and
So did the mayor.
And of course, the mayor. Yes, I was going to add the mayor as a special. And not only that, but Willamette Bethel School District is looking at building new schools, replacing Fairfield and replacing Malabon schools, very old schools that should have been replaced a long time ago, with no additional taxes to the people in the district. We had an opportunity to hear about it and get the message out. A lot of people were canvassing in Bethel over the weekend regarding replacing two schools. Pretty optimistic. It's a jobs issue. It's a student issue, and I knocked on a lot of doors over the weekend, and gosh, it's amazing how universal the support feels to be out there for building the new schools in Bethel.
So I just wanted to bring up something going to that made me think about, and I wanted you guys to think about, is when they were talking about that, they talked, their biggest selling point for that particular bond measure was that it didn't raise the tax rate. Does it remind you of some other thing that we are ourselves dealing with? And then they showed a picture of all the jobs it might produce. And does that remind you of something that we might be dealing with? And so I watched that video, and that selling to the public why it's a good thing to invest in the schools and get more without having to raise the tax rate. And I thought perhaps this council wants to think about how we'll have that similar conversation about a road bond that is moving forward, and maybe some of us can step up and make those selling points as well. So just want to put that out on your plate. I think we really need to start thinking about that. Did you want to say something?
I did. I agree with you about that, but I also would say that I agree with Betty 100% as well on the issue of parking.
Look at the surprise over there.
I think she's 100% right. I was too disappointed to see what I saw during the course of our break with regard to the change in rates, but Even more so, I'd hoped at some point we could review what we've done to this point and look to expand the footprint of it. And so perhaps we'll have a work session pulled before long and take a look at that. Or perhaps, if it's convenient to do so, the manager might fold that discussion into another opportunity in the future as well. Thank you.
So just a really fast couple things to say to you guys. Of course, during the break, it seems like it was even before break, but we do have the new police station up and going, and many of you were there for that. We had the Eugene celebration. The city manager and I got our test drives of Arcimoto. We had a very successful, I thought, joint elected officials meeting where we really talked about some progress we're all making on our regional prosperity plan and the work to move it forward. We had this weekend, yesterday, a fabulous Sunday streets turnout. If you saw the picture in the paper, you can see the kudos to our staff. Took a lot of work to plan, a lot of volunteers, and it was just a terrific, terrific event. You've got a Vets Housing Project ribbon cutting this Thursday, and Pat and John may have more to say about that. And then there's a ACT Lane Area, what is it? Transportation Commission, or Commission on Transportation meeting this Thursday. We'll be talking about the 2015 through 2018 STIP, money for transportation, and the emphasis on multimodal development, sustainable transportation solutions that are safe and low carbon. And so all that sort of fits into all the conversations we're having about how to do our land use and transportation planning. So those are just a few of the things that have been going on around town. City Manager, do you have anything you wanted to
I was just going to mention the Veterans Housing Project as well. You know that that's a community effort. 2 more homes. The ribbon will be cut on Thursday for that. The families that are moving into those homes are just absolutely wonderful families, and their stories are great stories. And really, remember what's being tried here is to provide a couple years of support and transition as the veterans and their families reintegrate into the community and just give them a chance to settle back into the community. So if you have a chance to come on out, it's 10:30 on Thursday out at Echo Hollow.
right across from Willamette High School?
Yeah, right across from Willamette High School.
Echo Hollow.
Yeah, so it's a lot of volunteers have been involved. They're working really hard today and tomorrow to finish up the last piece.
But they're going to do it.
Yeah, so anyhow, it's been great.
So how about, are you guys willing to quickly move on the consent calendar? Is that something you're willing to do?
Just a quick aside, our city managers worked tirelessly on that. Congratulations and good work on that, John.
Thank you.
So, Council President, would you move to approve the items on the consent calendar?
I move to approve the items on the consent calendar.
Second.
Moved and seconded. Any further discussion? All those in favor, please indicate.
Aye.
7 in favor and none in opposition, passes. So we've dealt with the consent calendar. We'll take up the alley vacation first, and then we'll have the community forum, and we'll be meeting at 7:30, and people can come into the room at 7:15. Thank you all.
Thank you.
Remember, your microphones are still on.
Yes. Live mics.
City Manager.